So I would love to welcome Rosie Heys, who is going to talk to us about her shocking experiences with the finance side of family law cases. So welcome, Rosie. Over to you. I know a lot of people are really excited about your presentation.
Hi. Thanks, Natalie, for organising this. When I'm speaking, I'm not just speaking for myself. There's a group of us that have assembled through Gingerbread, through Mumsnet, and through a Facebook page which I've set up. And the Facebook page is very regularly updated with changes as they occur. So you can find that. It's called Family Law Debt Litigation Loans. I'll put a link on the chat at the end of this quick 30-minute talk. So my subject is litigation loans in family law, but it really does cover an awful lot of the way that finance is dealt with in family law. Natalie said that I'm going to give you some tips on how to avoid your finances being impacted, or how to keep your finances intact through divorce. That's just not possible. They're not going to be intact. No one's finances ever are. But there are ways of stopping them being completely destroyed. There are ways of stopping you being thrown out of your home. And there are ways of finding a resolution without necessarily having to go through a whole protracted court case. Litigation loans started being introduced in family law in round about 2013, 2014. And this came out as a consequence of a judgment by Judge Mostyn. Now, the judgment by Judge Mostyn was that in relation to legal services payment orders, the weaker party financially would be entitled to make a legal services payment order to access finances, to have sufficient money to be represented in court. And his recommendation was that if you couldn't get funding elsewhere without causing yourself to become significantly indebted, then a legal services payment order was something that you would be able to access. The way that family lawyers interpreted this judgment was the exact opposite of what Mostyn had actually said. Instead of saying, okay, if there's a charge on the family home as a consequence of getting into debt, then, I'm sorry, that's my dog, I'm going to have to shut her up. Sorry about that, this is Alice. And she was going to bark all the way through, so I had to go and catch her.
It's an unconference, we're relaxed.
I know, and now it includes the dog. So instead of saying, okay, well, there are an awful lot of cases where the weaker party, and in my group, there are men and women who've been the weaker party. It's not, it's generally the mother, but it can be the father. And quite often it is, actually. The weaker party can get a legal services payment order. That means it releases some of the marital funds that have been kept by the stronger financial party, and those can be used by the weaker financial party. The lawyers interpreted this to mean that they could put a charge against the family home, the opposite of what Mostyn was saying, and get a loan to cover their legal fees. So, having given a bit of the background, one of the things that came out as I kind of contacted and heard from more and more people who've been sold these litigation loans, most of them from a firm called Novitas. And I'll come to the sub-postmasters case because Novitas is connected to Therium, and Therium are the guys who funded the sub-postmasters case, but I'll come back to that later. So most of the people who were sold these loans just went to their lawyers, or went to a firm of lawyers to get advice on divorcing. And what became clear was that the lawyers were saying the same thing. They were basically speaking from script. We subsequently found out that Novitas were actually providing in-house sales training to family lawyers to sell their loans. Now, the Novitas loans are really high interest by any standard. 18 to 33% interest is what people have been charged. And my question is, how could it be justifiable if one party can't actually afford to pay their legal fees, to effectively increase those legal fees by at least 18 to 33%? So it makes it even more unaffordable, obviously. It's an insane suggestion for lawyers to be telling a vulnerable person financially, and because you're divorcing a vulnerable person anyway by financial conduct authority definitions and by solicitors regulation authorities definitions, to sell them a high interest loan in this context when you're divorcing. Relationship breakdown is a vulnerability and you don't think straight. Anyway, so the lawyers had been given a script. They had had in-house training provided by Novitas, and they went gung-ho. At its height, Novitas had 900 family law firms selling these loans. So that could be anything from a sole practitioner to a family law firm that maybe had 100 family lawyers, all selling Novitas loans. The first thing that the lawyers would do is basically, they wouldn't ask, do you want one of these loans? And I've got written evidence from people who have sold these loans where they're saying, but I don't want one of these loans. I don't want to get into debt. I don't want to have the financial obligations that these loans are going to place on me. But the solicitors just went ahead and applied anyway. And it was presented as though this is a normal part of the family law process. If you've never been divorced before, you have no idea, and you don't know whether it is or not, but you trust your lawyer because you're supposed to be able to trust your lawyer. The first thing that they then, having put in an application to Novitas, and this is still ongoing, by the way, it's just Novitas has gone foot, but more have popped up. They submit the application to Novitas. They basically are creating a second charge mortgage, or in some cases a first charge mortgage, against the family home, but against half of the family home. So half of your equity in the family home. In some cases, they created 2 loans, and neither party is aware that the other one's got a loan as well. So at that point, you've got half of the family home being subject to a second charge mortgage with Novitas for the husband, and the other half of the family home being subject to a second charge mortgage with Novitas. And the 2 parties don't know that debt is just being piled up onto what is probably their greatest asset and the one that they most desperately need to protect if they want to keep the children in the family home and keep the children in their schools and not move out of the area. So suddenly you're putting people into a situation which is incredibly dangerous, that leads to a very precarious housing situation, and that leads to the erosion of marital assets, which means at the end of the case, when all of the finances are sorted out, if they ever are, and in my case, they still haven't been after 10 years, where you can end up with neither party being able to be housed, the children can't be housed. There are people in my group who have ended up sleeping in the spare bedrooms of their daughters' boyfriends. They've been basically made homeless and they have nothing. And these aren't people who can just pick it up and start again, because people don't tend to get divorced in their 20s. They tend to get divorced in their 30s and 40s or in their 50s. And by then, you're not that far away from retirement, and trying to build up a fantastic, successful career that late in life, it's not obvious.
But I think this is far worse than that, because I don't know if you're aware, I'm a member of Land Registry, the facts, and there is serious problems with the way that Land Registry is working. And I think once you're a target of this type of situation, you are open to all sorts of skullduggery with land registry and your properties.
Okay. I mean, that maybe would be a good subject to speak about in finances and family law in another session. It's not something that I've really looked into. So once these applications have been submitted to Novitas, Novitas never say no. It's always going to be yes. The property values that I've seen, every single one of them was an exaggeration, and not a single one of them was done by a chartered surveyor. All of the valuations for the properties, for the homes, were carried out, well, they weren't valuations, they were marketing appraisals. Now, anyone who's ever sold a house knows that the marketing price is always higher, mainly unless you're in a massively rising market. The marketing price that the estate agents are going to put your home on the market for is going to be higher than the price you're probably going to get for it. But on top of that, a market appraisal is not a document that can be used to secure a mortgage against. These are solicitors, and they are securing mortgages based on mortgage appraisals, which are exaggerated, they're overvalues, and they're not actually proper chartered survey valuations. They're not suitable for securing any form of debt against. And in a lot of the cases that I've seen, it actually says on the marketing appraisal, this is not suitable for divorce or lending. But the solicitors still went ahead with it. Once the loan had been accepted, a charge was put on half of the home. Well, you can see there's a problem with that, because you can't put a mortgage or a charge on half a house. It has to be on the whole thing. So a charge appears on the land registry on half of the house. And from that point onwards, you're in serious trouble, because you've now got a solicitor who has access to ready cash for anything that they do, whether it's necessary or not, and they can get that money very easily. There are various provisions in these loan contracts which are shocking, and I'll come on to those later. But there's also requirements that the Financial Conduct Authority have made, well, that is law under the Financial Services and Markets Act, but also under the Consumer Credit Act, that before you lend to someone, and in particular if you're going to secure the loan against their home, which risks making them homeless, you have to do an affordability assessment. And no affordability assessments were done, either by the solicitors or by Novitas. So people were basically taking out unaffordable debt. The solicitors would then march you round, and in two cases we've got the same firm of solicitors, the firm I went to, unfortunately, who literally frog marched you to the firm of solicitors next door, who were also selling Novitas loans, who would witness your signature, and then they would send a letter without you knowing about it, saying that you had had independent legal advice on the loan. Now, you couldn't argue with that because you didn't see the letter. They didn't show it to you. But what we received was basically 10-minute witness to signature. And then a few days later, the loan is actually drawn down on by the solicitors. And what came out in my case is that the firm that was selling me this loan, every time they sold a loan, they received payment from Novitas. They got £775 for every Novitas loan they sold. That's a hidden commission. That's what I say anyway. The SRA say it's not a hidden commission. But bearing in mind that the solicitors were also charging their clients around about 10% of the value of the loan to administer the loan, I don't understand why they were also being paid by Novitas every time someone signed up to one of these loans. It does look like a hidden commission to me. And the solicitors had tried to deny it initially, and then in the end admitted that they had been paid by Novitas to sell this loan. But they called it a payment for completing the loan. And at that point, you've got a trapped client. the advice that they're supposed to provide, the independent legal advice that they're supposed to provide, relates back to a case called Rrid, in which a wife was basically heavily indebted by her husband's solicitor, who wanted money from her to shore up debts that he had accumulated against his business. And unless advice is Rrid compliant, it's not sufficient. And clearly, a witness signature is not compliant in anything. You're not receiving any advice at all, but that's basically a rubber stamp. It's also in these contracts, one of the terms of the contracts is that you're not allowed to disinstruct your solicitors once you've taken out one of these contracts. You can't sack your lawyers. However bad a job they do, you're not allowed to sack them without the permission of Novitas or whichever litigation lender whose loan you've been sold. And that's in breach of Article 6 of the Human Rights Act. You're entitled to free choice of legal representation. It's been tested multiple times in relation to insurance companies, people taking out legal insurance who are restricted by the legal insurer in terms of what law firm that they could go to for advice. And it's been upheld in numerous cases at the European courts that you are entitled to free choice of legal representation. It's astonishing that lawyers were selling loans and are still selling loans that are in breach of the Human Rights Act, and that there's so much case law that supports the fact that you are entitled to free choice of representation. So you're trapped with a lawyer and you're trapped with a debt secured against your house, and interest is accumulating at a rate of 18 to 33%, huge amounts of money. One of the other things that happened repeatedly, not in all cases, but in a lot of cases, is that the other party, the joint owner of the home, the spouse, was not told that this legal debt had been placed on their house. So in some cases, people were turning up in court and the judge was saying, well, there's no money left. It's all gone in this litigation loan. And finding out there and then in court, they'd lost everything, that there was no money, and that basically they weren't going to get anything. It was a total, the money had gone to the lawyers and the money had gone to Novitas, and they didn't even know that a charge was being put on their property. The whole process continues then. These loans are not associated, to my knowledge, in mediation. It seems that the lawyers needed to encourage you not to mediate. And in all the cases that I know of, that's what happened. People were told you cannot mediate. Obviously, mediation is a lot less expensive. Going to court makes a much bigger profit for lawyers. And it also makes, of course, a much bigger profit for the loan companies, because the more the lawyers charge, the more profit the loan company makes. They're basically getting interest on every single invoice. So when you get your invoice at the end of the month from your solicitors, you add 18% or 33% to that, and that is the loan company's cut. Finally, going through the courts, anyone who has been through the courts knows that family court orders are unenforceable. If someone doesn't want to follow a family court order, particularly in the finance side of things, nothing will be done. And if something is done, it'll be done years and years later, at great cost. You've got very little chance of getting a financial order enforced if the person on the other side doesn't want to pay the money. They just won't pay the money. And what are you going to do? Call the police? Go back to court? A lot more expensive. It's all more money for the solicitors, more money for the loan company. And of course, the more money they get, the less money you and your spouse and your children get. One of the group that I'm in did a calculation based on the split of family finances when one of these litigation loans is present. And she found that it was a third, a third, a third, if you're lucky. That means that the solicitors and the loan company are basically going to get a third of your assets. And then you and your spouse are going to get a third each and a third each. And across the board, that's what we've found, that there was very little benefit from these loans, and you're basically just losing money hand over fist. So not only are the family court orders unenforceable, but these loans secured against a home, purportedly against half a home, you can't sell half a home. So even if the court order says the family home to be sold, if the joint owner doesn't want it to be sold, it's not going to get sold. So a load of people in my group, and me included, were left in the position where the order said you have to sell the family home in order to provide funds to rehouse you and your former spouse in smaller, cheaper accommodation in a different area. Fine, that was the outcome. But how do you sell a house if you need the permission of the joint owner to even list the house on the market, to even get an estate agent to list the house on the market? You need their consent to list it on the market. If any offers come in, you need their consent to accept those offers. I was speaking to somebody yesterday whose house had been blocked from sale for a decade. So she's sitting there with a massive litigation loan spiraling out of control, completely unable to sell her house, unable to pay, unable to force the sale of the property. And so, of course, unable to pay back the litigation loan. And that what happens then is you go all the way to repossession and bankruptcy. It's a terrible, terrible trap. So if you can't sell the house, you're just trapped. But then on top of that, if you do sell the house and it's got to a point where the debt has accumulated so much, you're not going to get any help from the council or any housing charities, because you're counted as having made yourself voluntarily homeless. So you've got, at that point, nowhere to go. You can't even get a council flat. The other thing that's come up repeatedly is that the financial position of the person borrowing the money, who was being sold the loan by the solicitors, was being misrepresented. So when I went through my court documents years later, I could see that actually they had said that the house was worth more than it was. They had said that I had more assets than I had. They said that I had more savings than I had. And when all of that was added up, it created a false impression for the judge and the barrister, in fact, of what my financial position was. So the court order, no one's going to enforce it anyway. But secondly, it was based on a fiction. And in a lot of these cases I've seen, that's the case, that the judge has said, this person needs 300,000 to buy a flat to rehouse themselves. And so I'm awarding them 300,000 from the marital assets to buy a house or to buy a flat. When you actually break down the numbers, there isn't 300,000 there. So even if the order is enforced, even if you manage to get the money, you're not going to get the money that was awarded because it doesn't exist. It's based on a fiction. So that's all bad news. Good news. One of the things that this group has done is engage with the financial ombudsman. And the financial ombudsman just turned things around. They basically assessed, and it's a long process and you have to be prepared to put the work in. But they assessed, in my case, the sale of the loan, the way that affordability had been assessed, if it had been assessed, what the legal advice I'd been provided with was, and whether it was worth anything. And they came back and said, this debt, this loan, was unaffordable at the outset. It was unfair, and it should never have been sold to this person, to me. But not only that, in other cases in my group, the same result has come from the financial ombudsman. So what we're sitting with there is that the financial ombudsman has determined that these loans that were sold 2012, 2013, 2014, and are being sold now by family lawyers, are being sold unfairly and unaffordably. And as a consequence, Novitas has been forced to refund all of the interest and charges. So Novitas, if you Google them now, you'll see that they are dead in the water. They have caused a £90 million hole in Close Brothers, who bought them, and they are now over. They are dead. There's no more Novitas. They're not lending anymore. But Novitas is owned by a firm called Therium, or Therium are deeply involved, or were deeply involved in Novitas. And Therium have just set up a bunch of other litigation loan funders in family law who are doing exactly the same thing. So although we've managed to kill one, there's a whole load more, and the family lawyers are still doing the same thing. So great, financial ombudsman has taken action and has found in our favor. And some people have received vast amounts of money back because the level of debt, I mean, in the case of one person who couldn't sell their house for years and years, the amount of money she got back was £120,000 in interest and charges. It's not enough for her to house herself, but it's a substantial amount of money. What hasn't happened is any action against the solicitors who were selling and still are selling these loans. The Solicitors Regulation Authority have been very cryptic with me, saying things like, the fact that you don't know whether we're taking action on these loans or not doesn't mean that we're not taking any action on these loans. But what I have seen is that Novitas and a lot of the loan companies involved in family law did not have Financial Conduct Authority authorization. And the SRA, in their guidance for solicitors selling debt, were very clear that solicitors could not sell debt from a company, they could not sell loans from a company which was not fully regulated and authorized by the Financial Conduct Authority. And that was there on the SRA website up until about 2020. And then in 2020, it changed. So this is what the SRA have done. It changed. And now solicitors can sell financial products from companies that are not fully authorized and regulated by the Financial Conduct Authority. So they've basically opened the door to solicitors selling unauthorized loan products from unauthorized companies instead of closing it. It's quite astonishing. Let me just check. I had a list of... So that's the SRA. They've been pretty unhelpful and actually quite dismissive of us. But the legal ombudsman, after 9 years, and it took them 9 years to make the decision, decided that in my case, they were going to uphold 13 serious complaints against the law firm that sold me one of these loans. There were 2 law firms involved. And this law firm, they like to call themselves the best law firm in London. And they're also one of the most expensive. I won't go into how I ended up going to them because I'm not the sort of person who would normally choose that kind of firm. So the best law firm in London, as they call themselves on their website, have had 13 legal ombudsman complaints upheld against them, in my case alone. Now, you'd think that that decision made by the legal ombudsman would be published, suitably redacted, but at least published, so that people who are approaching that law firm can have a think, do I really want to go to this firm? Because I can see that in this one case, 13 complaints have been upheld, that they have been found to have billed unnecessarily, they've given poor costs advice, they haven't. You'd think that that should be in the public domain, suitably redacted, and the financial ombudsman decisions are. They're all out there. You can look them up, you can see exactly how many decisions have been made against Novitas and what the reasons are. The legal ombudsman is the only ombudsman that does not have to publish decisions. So the most you're going to see, and I just need to check the exact wording, about the solicitors, in my case, and what complaints were upheld is this. These words are what is on the Legal Ombudsman website, and it's associated with the law firm, so I can tell you their name. The firm is called Payne Hicks Beach. They have a very famous solicitor called Fiona Shackleton, and she charges £1,000 an hour. So this is word for word all you're going to get about Payne Hicks Beach on the Legal Ombudsman website. Poor advice, information deficient, other. That's it. And that information will sit on the Legal Ombudsman website for exactly 12 months, and then it will disappear. If you look at the Legal 500 to see how Payne Hicks Beach are presented in the Legal 500, you really would not know that there had been any complaints upheld against this firm. You really wouldn't have any idea. You'd think that you basically walked into a firm that was really going to give you the best service you could possibly wish for. And that's the case with all of these law firms. When legal ombudsman complaints are upheld, the legal ombudsman does not publish the upheld decision. That means you, the public, just can't know whether they're good or bad, whether they're going to give you a good service or a bad service. You have nothing to base your decision to instruct a law firm on, and that's across the board, across legal services. There's no way you're going to know how bad they are until it's too late. Anyway, there are a few more things. I don't know how much time I've got left, Natalie.
I think that what you're saying is absolutely fascinating. It's certainly stuff that I've never ever heard before, so I would love you to just continue.
Carry on. You'll have to be patient with me because I'm going through my list. So where have we got to? Oh yeah, the legal ombudsman decision and the financial ombudsman decision. So where are we now? Well, I did mention the sub-postmasters. You probably know, everyone knows this case very well now. And one of the things I found fascinating about Mr. Bates versus the Post Office on ITV over Christmas was there was a moment there when Frith, the solicitors, are basically selling Ethereum to the sub-postmasters. And the wording leapt out at me because it was identical to what all of the people in our group had been told. There are these firms, they will fund your case. We recommend such and such. So I contacted one of the sub-postmasters who I've been following for years. And so he wasn't averse to having a chat with me way before the whole thing became the cool celebrity that it has become. And I said, you know, what happened? Because you guys ended up with 11 million. Sounds like a lot of money, but divided between 555 of you, it's not much. And he came back and said, I got £11,000. That's it. And he said, none of us understood what the contract was between Friths and Ethereum. None of us had really any idea. And when we started asking questions, they clammed up. They didn't want to talk. So this particular sub-postmaster made a complaint to the legal ombudsman. You won't know about the complaint, about whether it's been upheld or not, because of course the legal ombudsman will not publish their decisions. After a year, the slate is wiped clean. But in this case, the sub-postmaster said that Friths, or the law firm, I mean, they were found to have barely met the threshold that they needed to meet in order to provide a sufficient level of service. But barely met is good enough. So this sub-postmaster, and I can see other sub-postmasters posting about it a little bit as well, they feel terrible about having any complaints about Ethereum. At the same time, they clearly do have cause for complaint about Ethereum. And there's been another very recent case relating to
They got very lucky with their judge selection as well.
I'm sorry? They were lucky with the judge, yeah.
With the judge, yeah.
Yeah, I mean, I won't go into it because it's too long a story, but there's one judge whose brother sells litigation loans from Novitas, and he is the judge called Mark Rayside. His brother Dominic Rayside owns Family Law in Partnership. Mark Rayside is the judge who, sat on my case and basically decided that although the financial ombudsman had found that these loans were unfair and unaffordable, actually they were perfectly fair and perfectly affordable, and his brother is selling them at Family Law in Partnership. And I know that because one of my group was sold a Novitas litigation loan by Family Law in Partnership, Dominic Rayside's firm. So yeah, they were very, very lucky. They got a good judge, and that is a little bit of a lottery. Yeah, Rayside's wife is also a family court judge, and previously was a family court barrister. So, I don't know. Sorry, I've lost my thread a little bit. Oh yeah, the sub postmasters. There's been another case very recently, similar to the sub postmasters. I think it's the Road Haulage Association. Again, funded by a loan from Therium. In their case, and you're going to start thinking the sub-postmasters were lucky, in their case, they have ended up with nothing. Therium have walked off with every last penny of their award, every last penny. And there has been a bit of an outcry about it because they're getting none of the compensation. They're getting nothing. There's no visibility as well about how much of that money is going to the law firm and how much of that money is going to Therium. But I talk about Therium because, as I said previously,
But I'm not looking for compensation. I'm happy to get the message out there. I don't care if a solicitor or someone takes all of the compensation. As long as we can get message out there, fine. Because to be honest, if we can get into the same situation as the post office, look what they've achieved. They may not have got any money, but they've got the message out there.
I just think, the message isn't enough. These people are going to end up... Well, some of them are working as cleaning ladies when before they had a successful business. They need money. They need money. And the money's going somewhere. Why shouldn't it go to them?
Yeah,
so
to me,
I think it's not enough to get the message out there. It's really not enough to get the message out there. There needs to be accountability. There needs to be compensation. There needs to be people put back in the position they would have been in. If that doesn't happen, then the same miscarriages will happen again and again and again. The same mis-selling will happen. The same dodgy contracts will happen. Unless they are hit in the pockets, they will carry on doing it. And this is exactly what's happened with Therium. They've just set up a whole load of new brands doing exactly the same thing. And the family lawyers are quite happy to sell them, even though the financial ombudsman has determined that these are unfair and unaffordable debts. So it's all great to be high-minded, but it's a really, in practical terms, if you want to stop things, you have to make it so that they cannot afford to carry on. And that's where hitting them financially comes in.
But that's where
I think you should be a lot more... I'm sorry?
Would you be kind enough, I'm sorry, to sort of raise your hand. We've got some people who've got their hands raised and will be waiting to speak. Let's let Rosie finish and
Roly. All right. So, yeah, so because of Brexit, in the European Union, they are taking some very serious steps to regulate litigation finance, which will cover everyone, basically, who has one of these loans, whether they're taking a group litigation action like the sub-postmasters, or whether they're an individual like the people in my groups who are borrowing, who are being sold debt by their solicitors. At the end of the process, there's nothing done to assess whether or not the fees charged by the solicitors were necessary, were properly incurred. Now, in the case of legal aid, at the end of a case, a solicitor would have to submit to a judge an accounting for the money that they had charged. And what that meant was that overcharging in legal aid was less likely to happen because the costs were going to be assessed. When one of these loans is present, there is no such assessment of costs. So no one is going to turn around and say, I can see that your firm has charged you £250,000 and they haven't even got you to a final hearing. What's going on here? Are these costs being fairly incurred? Nothing like that happens. It's entirely up to the individual who has no idea of whether the costs are being fairly incurred or not. And in my case, turned out they weren't fairly incurred in a lot of cases by the legal ombudsman 9 years later. That's too late. You know, you need to know at the time, and then you can challenge the fees and get that part of the invoice wiped out. So there are no checks and balances, there are no protections for consumers. The Association of Litigation Funders is a self-regulatory body which deals with most, but not the ones in divorce, most of the litigation funders. Guess who owns the Association of Litigation Funders? Therium. So it's not independent, obviously, and there's nothing that they're going to do to stop this because it's for them it's such a big money maker. Every time someone gets divorced, you're walking away with 18% of that person's net assets. You're just going to carry on doing it. So to wind up, we have had success in getting things, getting redress via the financial ombudsman, but it is hard work. You do have to produce all of your documents. You need evidence. They're not going to listen to you otherwise, and rightly so. You can't just, you know, write a list of complaints and say it's not fair and expect to get any redress. But people have been getting quite a lot of money back. So a call out to anyone who knows of anyone who has had one of these loans: Novitas, Therium, Detach, Level, Ampler, Rate Setter, any of those. Make a complaint to the financial ombudsman and you should get back all of your interest and charges. And that should be a relatively high amount of money. If you have the stamina and if you have the capacity, because after all of this, you're exhausted and it's very, very difficult to fight. And I appreciate that. I mean, a lot of, I have had 2 people in my group I've had to talk out of killing themselves. It's awful. When you're in your 50s and you're about to be made homeless and you genuinely don't know where you're going to go, people sleeping on their stepdad's couch at the age of 50, people sleeping in their daughter's boyfriend's bedroom. I mean, that is debt causes suicide, and these debts are no different to any other, except that they're unfair and unaffordable and should never have been sold in the first place. It is worth fighting on, and please put anyone who you know who is being sold or has been sold one of these loans, get them to contact my Facebook page, which has a huge amount of information relating to these loans. You can also see photographs of the solicitors, but even the ones who sold me my crushing debt, at Novitas parties, bragging about the champagne that they're drinking. Novitas were holding parties at the Shard Shangri-La. They hired Tower Bridge, and they invited all of these family lawyers for piss-ups and canapes and parties. They invited them to Ascot. They sent them presents, as well as paying them, at least in my case, as well as paying them what I consider to be hidden commission, backhanders, basically. So yeah, do put them in touch with me. I will put links to the Facebook page on the comments, and I'll send those to Natalie as well. If anyone has any questions, fire away. And thanks for listening. Thanks for listening.
Rosie, thank you so much. That was really eye-opening and a really valuable piece of...
I'm sorry I went well over my time.
You know, you didn't, absolutely. We've got actually until 3:30.
Oh, okay.
So you're really fine. We've got plenty of time for discussion. I'd just like to make a comment that I really do believe, and this is adding to my conviction, that we, hopefully not criminal conviction, that we,
I mean, sorry, that's my coffee.
it's all right, that we have got to look at fundamental problems with the civil justice system, not just the family justice system. The family justice system is quite clearly an asset stripping racket. This lays bare exactly how bad it is, and this is not the only instance of it, not the only way it's happening, but in civil justice, in other areas as well. I've come in contact with people who have really been defrauded by criminals, and aided and abetted by people from the financial system, with the help of lawyers and judges.
Can I say, actually, quickly, one of the things that I'm not sure if I mentioned, overvaluation of assets, and what these solicitors were doing was overvaluing our homes, is mortgage fraud. It is fraud. There's also fraud by misrepresentation in attendance notes that the firm never expected me to get hold of, but I did manage to get hold of. The law firm PHB who sold me this Novitas loan, and there's another law firm still under investigation by the legal ombudsman for another, for doing the same thing, basically. They claimed that this was the lowest interest, that Novitas was the lowest interest. It was 18%. There was at that point another litigation loan company called Iceberg, and they'd been set up in association with Resolution. And they actually did have, at that time, checks and balances in place so that if the solicitors provided a poor service, you had redress. But none of the family lawyers were selling Iceberg, or very few of them were selling Iceberg loans. And the interest rate was 9%, not 18%. So there are a lot of frauds in this. There's another thing that I haven't covered, and I'll quickly just gallop into it now, if that's okay, if I've got time, which is astonishing. We all then found out years later that there were multiple appearances by a firm called RateSetter on our credit reference agency files. No one had taken out a loan with RateSetter. RateSetter is a peer-to-peer lending platform, and it's been described as absolutely analogous to an online gambling platform. And it was set up by a guy called Rrid, who now has an OBE. He's quite clearly a chum of David Cameron. If you look on my Facebook litigation loans page, divorce debt and litigation loans, it's called, you can see there's a photograph of David Cameron and Rrid on a private jet, basically hugging each other. But what was that to do with Novitas? How the hell did they become involved, and why are they all over our credit reference agency files? Some people had as many as 33 RateSetter residential mortgages on their credit reference agency files. And by a series of kind of coincidences and just being curious and pushing a little bit, when RateSetter were taken over by Metro Bank, and this is a bank that's partly owned by the public, so this is quite serious, we managed to get access to files, to accounts in our names with RateSetter. RateSetter denied these exist. Metro Bank denied these exist, but we got into them and we could see them. And these date back to 1753, the Napoleonic Wars. None of us are 250 years old. If that's not fraud, what is? I mean, what is going on? Solicitors were selling people loans purportedly from Novitas, but weren't Novitas, they were RateSetter. And then RateSetter was setting up accounts in our names dating back to 1753, to the Napoleonic Wars. And people didn't even know who RateSetter were. They'd never signed contracts with RateSetter. And through those accounts, in my case and in other people's cases, there's vast sums of money moving, supposedly from us to RateSetter. That money hasn't come from us. Where's it come from? We don't know. Again, I mean, everything I say, it sounds insane, it sounds mad, it's true. And the original documents, links to the legal ombudsman decision, links to the financial ombudsman decisions, and links to the contracts dating back to 1753. They're all on that Facebook page. You can have a good look, and you'll see the picture of David Cameron giving Rrid and Lewis a hug, and lots and lots of other information and evidence. It's all there. We haven't made, none of us are making claims that we can't back up with concrete evidence. So yeah, when you're talking about fraud in the family courts, great way to hide money laundering, all that privacy, all that secrecy, legal privilege, blah, blah, blah. No one would ever know. So if I was a money launderer, I'd be using the family courts, I'd be using family lawyers, but they're supposed to have anti-money laundering provisions in place. And everyone who's gone to a lawyer will know you have to provide them with your passport and proof of ID to show that you're not money laundering. What they didn't do is check where the money was coming from in relation to the Novitas loans they were selling. And from what we can see, it was coming from, well, we don't know, but it does look a bit dodgy. Oh, one other thing, they didn't bother checking, and they didn't bother checking, the solicitors selling these loans didn't bother checking whether Novitas was authorized by the Financial Conduct Authority at all. They just sold the loans and took the money. It's easy, it takes 2 seconds to go onto the Financial Conduct Authority, look at the financial register and see which firms are authorized and regulated and what they're authorized and regulated for. But the solicitors just didn't do that. So serious failures of just curiosity. They weren't even curious as long as they were being paid. Anyway, I'll shut up now, but if anyone has any questions or comments, I'm very glad to hear them.
That's amazing, Rosie. That's such great, sort of research into what has happened, and congratulations on, what you've managed to achieve. If this isn't just another level of institutional betrayal, after all of the pain that people have been forced to go through in family court with, their children, it taken away from them, causing these really visceral wounds, then to have this financial fraud inflicted upon them, and then to have to try to find the strength from somewhere to deal with that as well. Well, you can see, why somebody would want to exploit these people, because they're already so weakened, and it's awful. It's awful. I'm going to also shut up, and I would love to hear, Rosie, are you able to stay on for a bit? We have gotten to 1:30. We don't have to use that whole time.
Yeah, I'm really happy if anyone's got any questions. I did say I would try and help give you advice on trying to mitigate the costs in family law. A lot of talk by solicitors and barristers on Twitter and elsewhere that if you're a victim of domestic violence, mediation is unsuitable. And I disagree. When you go to the family court, you're going to be waiting in a courtroom. You're going to be waiting in a waiting room that is probably open. And if your former husband or spouse has been abusive, they get an opportunity to abuse you there. Even if you manage to get a private waiting room, you're still going to have to face them. And the way it works is they stand you face to face at the door to the courtroom, and you have to wait there facing each other until the clerk comes and lets you into court. And as a Mackenzie friend, and I don't Mackenzie friend anymore, so please no one ask me to Mackenzie friend for you. I don't do it anymore, but partly because I don't want to profit from this vile system. I saw it myself, it happened to me, and I saw it with people that I Mackenzie friended for. Those minutes when you're waiting to go into court last for hours, and they are used routinely by an abusive person to insult you, to intimidate you. They'll stare, they'll pull faces, they'll make hand gestures, they'll make comments to you under their voices. And you know what's really shocking? In my case and in other cases, I've seen family solicitors just ignore it, pretend it's not happening, not turn around and say, you know, can you leave my client alone? They're not going to bother. When you go into the courtroom, I've seen abusive people throwing files around, swearing at their former partner, and I've seen it excused by the family court judge. In the rare occasions where you might actually be able to get a split hearing, the person who's most likely to be in the courtroom is the abusive person, and the person who is non-abusive is likely to be watching on, attending remotely. Now, if you're not in the courtroom, conversations can happen between the judge, the barristers, and the people around the abuser that you will never know about. And you'll kind of suspect later that was something said once they turn the microphones off. It was. Something probably was said. And it can subvert the whole thing. So there's no protection in that. In actual fact, with mediation, you can have split mediation, you can have it in 2 separate rooms, and then a room where the 2 barristers will come together. You end up with the same result, a court order, which is then drafted and submitted to a judge who will decide whether or not they're going to agree to it. But you don't have to go to court and face face someone who maybe you don't want to face, and you don't have to go through all of that trauma. And in the end, you end up with an order that people can decide not to follow anyway. So save yourself the money, don't go to court.
I think maybe just caveat that with one thing, maybe it just depends which mediation, because yeah, I think a lot of the family court mediation is coming from the AFCC, Association of Family Conciliation Courts protocols that we were talking about yesterday with well, I don't know, we went so much into the AFCC, the mediation, I mean, sorry, but there are mediation products, you know, which have been devised and sold, which are very, very ideologically biased, and where people who've been through mediation in the family court context say that it's been extremely traumatic.
Yeah.
You know, abusive behavior has not been addressed. But that is not the only kind of mediation that
mediation, exactly. I also think it's, you know, it's either or. And if you're going to go into court and you've got someone who is easily inflammable and someone who's been abusive in court, it's a lovely playing field for them. They thrive in it, in fact, a lot of them. And if they're easily inflammable, they will get inflamed. So it can cause more problems than it solves. And there have been a couple of cases where people have approached me because they're panicking, because they're getting pressure from their solicitors to sign up to one of these litigation loans. And they've also had the fear put into them of going to mediation. And in one case, she didn't sign, thank God. She managed to resolve it all via mediation, and it worked. So not in all cases, but I would just say, if a family lawyer is trying to get you to turn against mediation, and if they're not covering all the various forms of mediation that are available, and they're not telling you about everything, you can't really trust them. And one other thing, Payne Hicks Beach are one of the most reputable law firms in family law. They were a complete waste of time and money for me. I mean, it was absolutely shocking. And the solicitor that I had was one of their senior partners, and he's a family court judge. And the things that he was saying and telling me were just not true. But obviously they would be true in his court, wouldn't they? Because it's his court and he's the judge and he makes the decision. But it really was quite shocking, the lack of expertise. And that was upheld by the legal ombudsman. So they can sue me if they want, but if they do, I'll be quite happy, because then I can get that legal ombudsman decision published, and they'll have to live with it. and it won't go away after 12 months. So what I'm saying is, it's not worth it. No solicitor on the planet is worth £1,000 an hour. No solicitor on the planet is worth £500 an hour. No solicitor on the planet is even worth £300 an hour. In the end, they're basically doing a lot of administrative work, form filling for the family courts, and the barrister is the person who's going to deal with your case. So don't waste money on expensive solicitors. That's what I'm saying. Don't be taken in by the hype. You can go to an inexpensive high street firm, find someone who's had quite a lot of experience, shop around. If you feel pressured, walk out. Record every single conversation you have with your lawyers, and particularly if they ring you up, if you send them an email and they say, can we discuss this? That's a huge red flag. It means they're going to tell you to do something that they're later going to deny they told you to do. So you have to record all of the phone calls. Otherwise, they'll make an attendance note, which you will never see. But if you challenge them in the future, if you go to the legal ombudsman, or if you even want to sue them for negligence, they will say, oh, but we've got this attendance note, which could be completely false. So yeah, record them. And they're not your friends. You're there for them to make money out of, and they will make money out of you.
I'm just realizing, actually, when we're talking this conversation that is about the sort of financial proceedings, it's not so much about the child custody proceedings. So,
no.
Yeah.
These loans were sold to people for both sides. So they were sold for financial. I didn't have any child custody hearings, although a vast amount of money was expended by Payne Hicks Beach on organising contact, which was completely unnecessary. It's just a waste of money. But in other cases in my group, yes, absolutely. These litigation loans were sold by lawyers in child custody cases and in cases where parental alienation had been alleged. And those cases are incredibly expensive because you can go back to court year after year after year. The cases can last a week at a time. In one case, one of my group, her case did last for a whole week in family court relating to custody, and she'd been sold one of these litigation loans. So had her husband. So by the end of it, they ended up with zero. All the money had gone to the family lawyers and Novitas, and they had nothing left. It was that's not good for kids to have parents, one of whom was actually had to go through bankruptcy proceedings because of the litigation loan. So yeah, they are used across the board. They're used for financial proceedings, and they're used for child, for custody, or for anything to do with family law. They'll flog you one of these loans if they can.
Thank you, Rosie. That's really insightful. I have to apologise to everybody. I'm eating because I haven't allowed myself a lunchtime.
I'm not surprised. I mean, you've had 48 hours now, or the marathons. So I really appreciate what you've done, Natalie. I think you've worked so hard, and you've been a great invigilator. Been watching all morning, and yeah.
Oh, thanks ever so much. Great. Thank you. I can see Carol she's got her hand up. I think she's first in the queue. Let me just open the queue.
I think that I might be wrong, but I think a lot of people are having, in my opinion, the misguided view that solicitors and lawyers are there to assist. It's like a poker game. You could go with a good hand, know your cards, and know which to play and which to hold. And for whatever sake, when you sit down to a card game, you don't trust the opponent. Okay? That's my view on it. Thank you very much for listening.
Yeah, well, actually, talking about poker and gambling, like I said, I mean, all of these Novitas loans had been transferred to RateSetter, which is a peer-to-peer lending platform now defunct. We own it now because it's part of Metro Bank. So any problems that come from that, we're going to have to pay for with taxpayer money. But yeah, the judge described RateSetter as absolutely analogous to an online gambling platform. What Novitas were doing in selling these loans onto RateSetter and what the solicitors were doing was putting our assets on an online gambling platform. The link with gambling is not, it's very real. It's a poker game, but it's being played, and you have none of the cards, and you don't even know the game is being played. You don't even know they're playing poker with your future or with your assets, or but they are literally, if you have a Novitas loan from between 2013 and 2017, potentially longer, yes, your divorce, your assets, your income, your home was being gambled on an online gambling platform by RateSetter. That's what was happening.
How do we find out? How does one find out whether that's...
Did you have a Novitas loan?
No, I didn't, because I don't trust anyone.
Well done, you, for not trusting them. I was stupid enough to trust them. But you're not going to find out that yours, if you didn't have a Novitas loan or any of these litigation loans, then you didn't enter the second round of hell that is, the next level of the casino. So you didn't enter that poker game. Anyone sold a Novitas loan, and there are a bunch of other brands that I've mentioned that were also Ethereum owned and possibly also funded by RateSetter. They were basically gambling your life, everything you owned on this online gambling platform. Yeah. But if you didn't have one, then you're not going to find, that you're not going to find anything in that respect. It only happened, to my knowledge, it only happened to people with Novitas or other litigation loans.
Thank you for that information.
That's okay. Thanks, Carol, for the question.
Thank you. Alison's got her hand up.
Yes, hi. I was just thinking about the statement which was made about the post office and them being lucky to have the judge that they had. And I would, from my experience, say that it wasn't luck, it was judgment of the judicial services, probably very aware that they had the publicity and the documentary, therefore putting forward a corrupt judge would just highlight the issue. So therefore I wouldn't give them the benefit of saying it was a lucky that they got that judge. I think it was very much part of the plan where they have to step back and see how much damage it would cause the judicial system to put the usual characters in place. Because I've had experience of where a judge in my case was the ex-husband's father, barrister's father, sorry, not his father, his barrister's father.
Oh,
so
God.
I had to bring that to the judge's own attention. I'm thinking it's there in the information, and yet there you are. So yes.
I think one of the other things that's part of a campaign now that various groups are involved in, and I think the court said are involved, and Shira, is trying to get undoctored transcripts free of charge. So for me, two things I'd like to see. I'd like to see all of the legal ombudsman decisions published, suitably redacted, but published and left on the legal ombudsman website so that anyone who's engaging family lawyers can have a look at the record of this family law firm before they start paying them a fortune. And I don't see what the complication is with that. All other ombudsmen do it. The legal ombudsman is the only one. I've done some research on it, and there was a discussion in Parliament about the legal ombudsman and whether or not they would publish decisions. And it was decided that the legal ombudsman would not name and shame. And for me, if someone has screwed up massively and caused such harm, name and shame them, and it'll stop others doing the same. So that's the first one. And then the second one is, yes, these transcripts, we need them. We need them undoctored. I'd rather have the recording. than the transcript in writing, because the judges change the transcript. And so many of the cases I've Mackenzie friended at, I'm kind of like, well, the judge said this. I heard the judge say something racist or sexist or make disparaging comments about someone being raped. I mean, I've been in the room when that's happened. When you get the transcript, it's disappeared. I mean, so yeah, we need, transparency relating to the publication of legal ombudsman decisions, and we need those transcripts from the courts so that the proceedings can't just be falsified, basically. Sorry, my doorbell, someone's ringing.
No worries. Yeah, sure. Expect the greatest integrity from lawyers and judges, and therefore it seems like there's a special case really for a lasting record of misconduct. And I'm saying, integrity is so important.
Yeah, we have to. If we don't trust the courts, then we don't have. Well, what are we left with? I mean,
yeah.
We can't trust our lawyers. I don't trust lawyers anymore. I'm willing to accept that there are some exceptional people who are not going to exploit their clients, but an awful lot of them are, that's what they do, I'm afraid. Sorry, but that's.
I think most of us have reached that conclusion, sadly. Kate has got her hand up. Kate, please go ahead.
Thank you. Please forgive me if this has already been answered, but do you happen to know if these litigation loans are also happening in the United States?
They are. So Novitas did go over to the US and try and sell their product. Initially, they were basically battered out of the US, to the credit of the USA. I mean, great. They are very well connected, these people. They're they have friends in high places. And they went back again and started selling. They actually did succeed in managing to infiltrate the US market. So unfortunately, yeah, they're out there now. The reason that they were rejected initially, though, was because the way that punitive damages work in the US is pretty good, a pretty good disincentive to people actually behaving in the way that these people have behaved. So having got these legal ombudsman decisions, these financial ombudsman decisions, we should be in a position to mount a group litigation and sue the pants off Novitas, Close Brothers, Therium. They have the money. But in this country, punitive damages and punitive compensation is not awarded. So you won't get much for mental harm, even if you've been made homeless and attempted suicide, for example. You'll get something in the region of £5,000. And punitive damages are nothing like they are in the US. So that's why they were booted out of the US originally, because basically they knew it was going to be a free-for-all. They would get sued to bits in group actions the minute they stepped out of line. I'm not sure what happened that meant that they could, but they are in the US now. I don't believe they're calling themselves Novitas anymore. They're also in Australia, which has a very similar legal system to the UK. In Australia, they're trading under the name Plenty, Plenti, with a heart over the top. So yeah, unfortunately, they're kind of going all over the place. You're protected in the EU. You're not protected outside of it.
Well, thank you so much for your presentation. I do expert witness testimony in coercive control, and I was unaware. I haven't run across this yet with any of my clients, so I appreciate your presentation because it gives me a heads up and something to look for.
Look out for them. When I was Mackenzie friending in 2 cases, and I did an awful lot of this at one point, in 2 cases, both women, and they were both I mean, one, it was quite a high net worth case, and in the other one, she was, you know, career high flyer who'd basically supported her husband throughout the marriage. And both of them were going, you know, what's going on? How's he paying the lawyers? And I kind of went, well, let's ask if there's a litigation loan. And in both cases there was, and they hadn't been told. But in one case, the hearing had been adjourned because the spouse had such serious mental health problems that the judge ruled that the hearing had to wait, it had to be adjourned, and it would have to take place in 3 months after this person had had mental health treatment. And it was during that 3 months, when this person was having mental health treatment, that his family lawyers sold him a Novitas loan. I mean,
That's appalling.
the guy was pretty much sectioned under the Mental Health Act, and yet his own lawyers managed to sell him. And this is a case that was coming towards its conclusion. The sum of the litigation loan without interest was £75,000. And that was for a hearing that was going to last 2 days. I mean, it's so clearly stupid money and unnecessary. Why on earth were they, how on earth were they going to spend £75,000 on a 2-day hearing? Absolutely, you know. In the other case, we asked the question, and the guy had serious. Again, the guy was an alcoholic. This was a child case, fact finding, and there'd been a whole load of terrible abuse. It was absolutely awful. And this is the judge was Alison Rayside, actually, in that case, Mark Rayside's wife, whose brother Dominic Rayside sells these loans. But in that case, the guy had drug addiction. He was drunk on the stand in the family court, swigging from a gin and tonic, you know, a tonic bottle that smelt of alcohol. I mean, and he'd been sold a litigation loan. I mean, someone who is addicted is undergoing treatment for alcoholism, is undergoing treatment for their mental health, is, you know, terrible. And the lawyers are selling him a litigation loan. I mean, how is that legal?
I'm not sure we're even using the vocabulary that we need to express how serious and how appalling this is. I'm saying, I'm not sure it's even, it's very difficult to find a vocabulary to express how appalling this is.
It is unconscionable. That's the only word for it.
Yes.
It's immoral. It's unethical. It's fraudulent. It definitely, you know, we've gone to the SRA, and I'm not alone. I'm not isolated. The SRA are just palming us off again and again, and the level of patronizing. I mean, the level of patronization is off the scales. You can. It doesn't matter how intelligent you are, or how you can present yourself. None of it. It doesn't matter what your qualifications are. They're going to ignore you, and they're going to ignore you twice if you're a woman. So, very difficult to make any progress. Plus, my MP is Greg Hands, and the people who are selling these litigation loans actually live in the same. They live in my area, so, and they donated to the Tories. So I can't get my MP to do anything about it. I'm hoping he'll get unseated, and then the incoming one will maybe do something about it. Let's wait and see.
I think that families should really get together and take to task people like the SRA and other legal regulators.
So the SRA have a compensation fund for firms that have behaved badly and been closed. And in one case in my group, the solicitor was, just one case, the solicitor was found to have defrauded the client and is now in prison. And that one solicitor has cost the SRA compensation fund £4 million. So, and that's not even given full compensation. And by compensation, I mean that the people get the money that they should never have lost back, the money that was stolen from them. They get that back. They haven't even been given the full amount of the money that was stolen from them back. So that's the SRA. The SRA fund now is completely empty. Everything, every penny has gone because they have allowed so many dodgy solicitors to carry on. They've had to pay out so much money that now there's nothing left. The cupboard's bare.
Shocking. What about criminal liability? I mean, we know that if we were to, make police reports about these things, that exactly how much wouldn't be done, but
it is an avenue that we've considered, and I am going along to the Houses of Parliament next week for the all-party parliamentary group on fairer finance. That's another group that's been really helpful to us. A guy called Andy Agathangelou, who's absolutely wonderful, and he works with Lord Seeker, Prem Seeker, who is a very senior accountant who sits in the Lords and fights against financial fraud, along with Anthony Stansfield. And Anthony has worked with one of our group who's had the most egregious fraud committed against her. And the point of that is to try and get some action taken relating to the fraudulent sides of these, I think, loan shark schemes. So the exaggeration of mortgage, the exaggeration of assets, the fraud by false representation, the backhanders, the hidden commissions, that's another form of fraud and bribery. There are an awful lot of things that are being done by lawyers that are arguably fraud. But one of the things the sub-postmasters found as well is once the case had been overturned, some of them went to the police and the police laughed them out of litigation. They don't deal with fraud, not that fraud. So they might deal with someone fraudulently selling you a pair of Nikes down the market and pretending they're real. They might deal with that, and they might arrest some kid who's just trying to make ends meet, but they're not going to arrest the guys at the top who are making vast sums of money out of this. But yeah, that's the way things are now. It might change, and it won't change unless we fight to try and get change. So.
Is this what they call white collar crime?
Yeah.
Yeah.
And there's a lot of it. I mean, we know there's more and more of it coming out now, but really the post office was white collar crime. What Paula Venables and her little gang were doing was stealing from sub-postmasters and pretending the sub-postmasters had stolen from them. But it's classic white collar crime. And what's emerged is that the board of the post office knew in 2013, but their bonuses were related to profits. And if the money that they took off the postmasters, claiming that there were these shortfalls, that went into the profits of the post office and boosted their pay packets. So there was a direct financial consequence of all of these prosecutions. The more money they made from the prosecutions, the more profits the post office had and the more bonus the board got. Yeah.
It's so... James, oh, sorry, maybe that was an accident. Hi, lovely to see you. That's James is teed up for the next session, which is at 3:30, I believe. Does that mean we've got an hour's break?
I think we should have a break. I think we should have a break, Natalia.
Yeah.
You must be exhausted. Go and have a cup of tea.
Yeah, glad to see James is online because I know that Rrid, who he's going to be talking with about the mother and baby homes at 3:30, said that Ireland has got a storm warning at the moment. So we're hoping they'll be able to join at the moment. Hi, James. Lovely to see you.
Yes. Hi.
Hi. Did you want to ask a question about this session?
No, it was a mistake.
Oh, that's okay. Yeah,
I've only just come on, so I didn't know really what the substance of the conversation was.
Yeah. It was about actually, fraudulent, financial crime in the family courts. We're looking so much to seeing you later. I just actually wanted to wrap up by saying to people, I don't know if you know, in the United States, psychiatrist Dr. Bandy X. Lee, who has spent 20 years working with criminals in some of the most violent prisons in the United States, Rikers Island, which is no longer open. You know, a lot of this was like, you know, gangs, very, you know, extreme violence. She is saying that what is happening in the family courts is, it's like gang behavior, it's organized crime. You know, these are, you know, practically that is, you know, working like cartels. Yeah, so, you know, she's pretty unequivocal in the language that she's using. You know, I agree with what somebody said earlier. It's not everybody in the system. There are people in the system who are different, you know, who would like to do good, you know, who are not out to fleece people intentionally. We've got to try to somehow find, you know, alliances with people like that. But, you know, I think it's just important for us to be aware of what it is that we're dealing with. I was as naive as anybody else when I walked into all of this. So, yeah, and I'd just like to say, you know, once again to Rosie, that was just such a phenomenal presentation. Thank you. I think we're all very grateful to you, you know, for your time, for sharing this.
Thank you. That was my first, so thank you very much.
Oh, you did brilliantly.
I'm just putting the details of the Facebook group.
Mhm.
Please send anyone that you know who has got one of these, been sold one of these loans, has been sold one of these loans, is considering signing for one of these. Please put them in touch, and I'm happy to chat. And I don't, you know, I will try and dissuade them with every bone in my body. But you know, that it was a pleasure. Thanks very much, Natalie.
Thank you so much. Absolute pleasure. Brilliant. Okay, folks, shall we take a break, take a breather, and see each other at 3:30?
Can I just stop you a second?
Please go.
What time is it? What time is it there now?
So it's now 2:30 here in the UK and Ireland, so that would be in 1 hour from now. Is that okay?
Oh, because I'm in Australia.
Yeah, are you able to make it? Is it very late for you, or?
Oh, well, it's 10:30 now in this country.
Oh, I'm so sorry.
I thought we were 8 hours in front of you. That wouldn't make it. I thought it was 3:30 there and 10:30 here. Maybe I'm wrong. It doesn't matter. So we're not on now for another hour.
Well,
Can we continue now? I'm willing. I don't know if there's a show of hands from people, if we can see who else is willing to continue. Obviously, your platform. So I'm sorry if I'm intervening.
I can
because
see
Breda Murphy is not on. Obviously, isn't on now.
She's
on. Okay.
Thanks very much, Rosie, for putting that article in the link. Hang on, I'm just going to stop the recording for a minute.
Yeah.